afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Here we go again, folks. Mr. Daniel M. back in court and somehow still convinced he can outsmart the system all on his own. No lawyer, no backup, just him, a mouthful of gum, and a judge who has zero patience for games. The charge? Resisting and obstructing a police officer, a high court misdemeanor that can land him up to 2 years behind bars and thousands in fines. Not exactly something you want to face solo, but Daniel thinks he's got this. He sits there smug, trying to act like he knows more than the judge. And let's just pause here, because who strolls into a courtroom facing serious charges, chewing gum like they're waiting in line at a gas station? That alone tells you how this is going to go. The judge lays it out crystal clear. You represent yourself. You get treated like an attorney. No favors, no shortcuts.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Gu, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying. because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We could try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
Either know the rules or you crash and burn. And folks, you can already feel the crash coming. When the judge asks how he wants to proceed, Daniel mumbles something about discovery and evidence. But the problem? None of it makes sense. The prosecutor even admits, we've already given him everything. Yet Daniel insists he hasn't seen any exculpatory evidence, as if the state's supposed to hand him proof of his innocence. The judge finally cuts through the nonsense and sets a date for a full preliminary exam in January. And here's where it hits you. This man is digging his own grave. He's facing charges tied to assaulting a police officer, he's already lost custody of his child, and still he struts in acting like he's in control. This is classic sovereign citizen energy, smug, stubborn, and blind to the disaster they're creating for themselves. Judges hate it, juries hate it, and honestly, viewers hate it too. It's self-destruction in real time. Now January's hearing is set, and you already know it's going to be fireworks. If this is how Daniel acts before the real trial even starts, imagine what happens when the evidence rolls out. Will he finally get a lawyer, or will he keep tanking his own case? Stick around because this story is far from over.